Good afternoon, everyone, and welcome to our webinar. For those who don't know me, I'm Alex Fisher, and I'm a partner in the Employment and Business Immigration team here at Travers Smith. And with me is Moji Oyedaran, a senior lawyer in the team who specialises in business immigration. Now, it's fair to say that for many businesses, the focus has recently been the coronavirus pandemic and dealing with the fallout from that. However, with the end of the Brexit transition period fast approaching, we wanted to bring you this webinar to provide a bit of an update on where we are with Brexit and look at the key immigration implications. Some of you may have joined our immigration webinar back in September. If you weren't able to join, please do check out the recording on our website. Now, today's webinar will be an update on that previous session, and we'll be looking at the more recent developments and updates, including the immigration rules for the new points-based immigration regime, which were released on the 22nd of October. One key update for you is that we now know the regime will open up on the 1st of December 2020, so in just a few weeks. So now is a good time to revisit this. So in terms of what we're planning to cover then, we'll take a look at where we are now with Brexit with regards to immigration and how things are shaping up beyond the end of the current transition period. We'll then look at the new points-based immigration system and the significant changes that are being made in relation to the employer-sponsored visa routes. Then we'll go over what the impact of the changes will be for employers, including in relation to budgeting and costs, right to work checks, and then close with a few tips to prepare over the next few weeks. So jumping straight in then with where we are on Brexit. Well, currently we have about 6 weeks left to run until the end of the current transition period at 11 p.m. on the 31st of December. The transition period has helpfully meant that there have been no big changes following Brexit Day on the 31st of January 2020, and EEA nationals have continued to enjoy freedom of movement under EU law, and the status quo has been maintained. EEA nationals and Swiss nationals and their immediate family members continue to be able to live and work in the UK without any restriction or additional visa formalities. But of course, that is changing, and freedom of movement will come to an end on the 31st of December. The government's immigration bill to bring this into law was actually passed just last week. From the 1st of January 2021, EEA nationals will be subject to the same immigration requirements that currently apply to non-EEA nationals, including the need for work visas, and Moji is going to take us through the detail on that a little later. But first, we wanted to look at your existing EU workforce and what you need to think about there. So Moji is going to kick us off here.
Thanks, Alex. Now, in relation to your existing EU employees, we've known for some time now that the EU nationals who are already in the UK will be able to stay on and will need to apply for status under the EU settlement scheme in order to maintain their rights of residence after the transition period ends. Now, that scheme is open to anyone already in your workforce or anyone you recruit now who moves to the UK before the end of the year, so before the transition period ends. They will need to apply for status under the EU settlement scheme, and the deadline for them to apply is not until the 30th of June 2021. So there's still plenty of time for them to apply. But we do know that application processing times are starting to slow down quite a bit now. And generally, it's better to apply sooner rather than later, just so people have time to address any issues before the deadline rolls by. Now, in terms of the status EU employees will receive when they apply, they will be granted either settled status or pre-settled status, and that depends on how long they've lived in the UK for. Now, settled status is granted to people who have lived in the UK for at least 5 years, and it will allow them to remain here permanently. Where you have an EU national with less than 5 years of residence, they will be granted pre-settled status, which will be valid for 5 years. And the idea is then that they will be able to apply for settled status once they meet the 5-year period of residence needed. Now, there's been some confusion with employers where they've thought, well, they can't ask their EU employees whether they've applied for the settlement scheme, or can't even mention it at all, because it could be seen as potentially discriminatory. Actually, I think it's fine to ask if people have applied, if what you're doing is you just want to check whether they know about the scheme, and you want to signpost to them the government website and all the information they need about making an application. You may also want to ask them for evidence for your own records to see if they've been granted status. That way you know which employees you still need to follow up with or offer further support to as we get closer to the deadline. Of course, you can't force employees to apply now because, as we've said, the deadline isn't until the 30th of June next year. So that's sort of the balance you have to strike. And we've worked with a number of clients in relation to their comms to make sure they're providing the information and making sure they're striking the right balance with those types of the follow-up. Now, moving on to UK nationals in the EU, where you have UK passport holders who live and work in the EU, they will similarly need to apply for status in the EU 27 member states in which they are living. I know some countries have had to suspend or adjust their application processes just because of the pandemic and the implications of coronavirus. But I think to a large extent, these processes have now reopened. And as with the EU employees you have living in the UK, there will be a deadline for UK passport holders to apply in the country they're living, and that is also the 30th of June 2021. And they'll need to follow the applicable rules in the country that they're living in. So it does differ from country to country. So again, for employers, it's really about making sure that any of your affected employees are aware of the processes and the deadlines so they can apply in good time.
Thanks, Moji. So that covers people who are based in one location. However, we also need to think about people who travel and work across borders, who will also be impacted by Brexit. The so-called frontier workers, so staff who live in one EU country and work in another. Of course, at the moment, that's not a problem because of freedom of movement. However, it will be an issue once freedom of movement ends. If you have any employees in this category, they will need to make an application to preserve their status as a frontier worker, so they do not become subject to the new immigration requirements that will apply from 1st of January 2021. The UK is introducing a frontier worker permit, and we now know the route will open for applications on the 10th of December 2020 to allow EU nationals to apply. It will be similar to the EU settlement scheme and will be an online application process. Employees will have until the 30th of June 2021 to apply. It's a good idea to work out if you have anyone in this category now and think about what you need to do to get them lined up to submit their application once the process opens.
So looking now to business travellers, a UK passport holder is free, as we know at the moment, to travel to the EU and across the EU for any purpose, so holiday or business, without restriction. Once the Brexit transition period ends, however, UK passport holders will become subject to the same entry requirements that apply currently to non-EU nationals. So they'll need to qualify for entry as a third country national, so local rules will apply to them. So that will be quite a big change. Now, we know there's not going to be a visa requirement imposed, but when entering on a visa-free basis to the EU for business, UK passport holders will need to be aware that their planned business activities in the EU will need to fit within what is permitted in the country they're visiting. So typically, meetings will generally be fine, but somebody going across to, say, France to fill a vacancy or to provide temporary cover would require a visa. So there's no right to work going forward. If you have frequent travelers, you probably want to start thinking about giving them a so-called back pocket letter, which they can then show to immigration if they're asked questions on entry at the border. The aim of the letter would really be to help them to easily confirm that their employment is based in the UK, and also talk about cover the planned activity and the purpose of their trip to the EU. Now, the other big change is that passports will need to be valid for at least 6 months from the date of entry to the EU. And where you have passports that have been issued for longer than 10 years, so there used to be a practice where if you applied early, you would get the extra period added at the end of your of the expiry date on the passport when it's issued. You need to be aware that actually that extra period won't count towards the 10-year validity that the EU counts. So people need to have a look at their passports basically and make sure that they're applying for a new passport if they need to in good time ahead of any travel to the EU from the start of next year. Now, if you have people you actually need to send to your EU offices to undertake productive work in the EU, e.g. you have somebody who is going off to complete a secondment, they will need a work visa going forward because there's no freedom of movement available to UK passport holders anymore, and that will be subject to local immigration rules depending on the country that they're going to.
Okay, so far we've been looking at your existing employees and how Brexit will impact them. Now we'll turn to look at new hires and what implications the new points-based immigration system will have on recruitment. The government has enacted legislation which means that from January 2021 onwards, EU nationals will need work visas for the first time and will be brought in line with the current system in place for non-EU nationals. So it's worth reminding ourselves what the current Tier 2 visa route looks like. The starting point is that an employer must have a sponsor license to sponsor non-EU employees. So individuals from the US, Australia, Japan, or wherever outside of the EU. Only jobs which meet a minimum skill threshold, currently set at NQF level 6, which is broadly degree level, will qualify for sponsorship. There is a special list of jobs that have been assessed as meeting this level. The individual must have sufficient knowledge of English. They can rely on a degree taught in English, pass an English language test, or if they are from a majority English language speaking country, they can rely on that. You also have to advertise for the role and show that you can't find someone suitably qualified from the UK or the EU. And for lots of roles, that's quite difficult. If you're recruiting someone senior who will be earning over £159,600 per year, then you don't have to advertise under the current system. A minimum salary threshold of at least £30,000 or the going rate for the job type, if it's higher, is also required. And finally, there is a cap of 20,700 a year on numbers, which breaks down into a monthly quota. To sponsor someone from outside the UK, you need to apply for an allocation from that quota under the monthly allocation cycle. So that's what the current Tier 2 skilled worker route looks like. Moji is now going to take us through how the new skilled worker route will work.
Now, the skilled worker route. Now, the first thing to say about the new skilled worker route is that it opens up on the 1st of December 2020. So just a few short weeks to go. The current Tier 2 general route will be replaced entirely when the new route opens. Although the route will be closed, existing Tier 2 visa holders will be able to continue with their visas will remain valid. Now, if you have any extension applications or any new applications that you're starting from the 1st of December onwards, then those will come to be decided under the new immigration regime. Now, the second thing to say is that it is closely modelled, even though it's a new route, it's closely modelled on the existing Tier 2 visa routes, which Alex outlined. A key component of that is that employers need to have a sponsor license, and that part is staying. So we still, as an employee, would still need to have a license under the new skilled worker route. What we've been told is that any employer who has an existing Tier 2 general license under the Tier 2 category, the Tier 2 general category, it will be automatically changed over to the skilled worker route once that opens up in December. Now, there's some key differences to the new route, which I'll just run through. Firstly, there's no advertising requirement, and also the annual quota is being removed. Now, these two elements should make applications a lot quicker because they remove several weeks from the process. To qualify, an individual will need to score at least 70 points from a set of characteristics. These include holding a job offer from a licensed sponsor, meeting the minimum skill level, and then they also need to have knowledge of English and also meet the salary threshold. These elements are all, they would sound familiar from what Alex said, they're all part of the current Tier 2 general system. However, unlike the current system, with the skilled worker route, there's a bit more flexibility around how an individual can score points in order to qualify for the visa. And it's actually going to be possible to trade off points across different characteristics to actually meet the requirements. With the current Tier 2 general route, all of the points are mandatory, whereas with the skilled worker route, an individual with a slightly lower salary can obtain the extra points they need by having a different, a PhD qualification, for example, that is relevant to their job. So to look in a bit more detail and drill down a bit more into the point scoring and how the trade-off will work in practice. Now, so an applicant, as I've said, needs to have a job offer from a licensed sponsor. If they have that, they would score 20 points. Now those initial 20 points, that is mandatory. So if you want to sponsor a visa of a non-EEA national or an EEA national that moves to the UK after the 1st of January, you will need a sponsor license as an employer. Now, it's also mandatory for the individual to meet the minimum skill level. So that means they have to score 20 points for the type of job. So the job on offer will need to be skilled to at least A-level standard or NQF level 3. Now, as Alex has mentioned earlier in relation to the current Tier 2 general route, this current skill level is graduate level, so NQF level 6. Now, the new level is a lot lower, so that means there will be a wider pool of jobs that can potentially be sponsored. So that gets the individual to 40 points. Now, applicants need 70 points overall. So in order to score the remaining points, they need to meet the English language requirements. So that's set at level B1, so you can meet that requirement by either being from a designated English-speaking country, so for example, Australia, the US, Canada, and then under the new rules, new countries will be added. For example, Malta will also be on the list. Or they can hold a degree that was taught in English. That is, so it has to be a qualification at degree level or higher. So if neither of those apply, then the individual needs to take a test from one of the approved English language test providers. So that gets them to 50 points. Now, the remaining 20 points can be from a combination of their salary being at the going rate for the role, and that's all part of being designated by the salary level designated by the UK authorities. Or if they're coming to undertake a role that is considered to be shortage in the UK market, they would score points for that. Or the job, if the job requires an individual with a relevant PhD or a relevant STEM PhD, there's an opportunity to score points for holding those qualifications. Now, if you're recruiting somebody who's a recent graduate, again, they are able to offset points in relation to being a recent graduate, so they can qualify relying on that status.
Thanks, Moji. So, as well as the new skilled worker route, there is a new intra-company transfer route, which also opens on the 1st of December, and similarly replaces the current intra-company transfer route. This route is for multinational companies with offices or group companies abroad. You can bring employees from overseas offices or group companies to work temporarily in the UK. This route is not changing very much, and the requirements under the current Tier 2 intra-company transfer are being retained. Again, you'll need to have a sponsor license, and it is worth checking if you're registered under the intra-company transfer route, as some clients are only registered under the general route. Also worth pointing out that for this visa route, there is a much higher skill level than the skilled worker route. The skill level for this route is not being lowered and will remain at the graduate level. There will therefore be some jobs that will now qualify under the skilled worker route, which will not qualify to be sponsored under the intra-company transfer route. The key benefit to this route will be the fact that the employee doesn't need to demonstrate any English language ability. There's no English language requirement. Unless their salary is at or above £73,900, they will need to have been employed with you abroad for at least 12 months, so in the same company or a group company. The salary threshold for the intra-company transfer route is also much higher. So for the skilled worker route, we said it would be £25,600. But for the intra-company transfers, you'll need to pay a minimum of at least £41,500. The final point to flag here on the intra-company route is that this is a temporary visa. There will be a maximum of 5 years on this visa, except for high earners who will be able to stay for 9 years. But this route does not lead to settlement. If the employee wants to settle permanently in the UK, they would need to switch to a skilled worker visa, which they will be able to do, provided they meet the points threshold for the skilled worker visa. An important change here is to the cooling off period. Currently, if you've been on an intra-company transfer visa, once you leave the UK, you have to wait for at least 12 months outside the country until you can apply to come back on another Tier 2 visa. Going forward, it will be a bit more flexible. The only restriction is that you cannot be on an intra-company transfer visa for more than 5 years in any 6-year period. So effectively, the 12-month cooling off won't kick in until you've done 5 years. Okay, we have a couple of quick case studies to highlight how these new visa routes will work.
So let's take a look at the first case study, which is focused on the skilled worker visa routes. Now, so Jamie has a job offer as a software engineer and is looking to move to the UK in February 2021. He's a Spanish national. So the salary on offer is 35,000 per annum. So how could he score points for under the skilled worker route? So he would get 20 points if his offer is from a licensed sponsor. So if his employer holds a sponsor license already, or is able to apply for one in time before the February date, then it could score the 20 points. He then needs to have, he needs to score 20 points for meeting the skill level of NQF level 3 as the minimum. Now, the skill level is matched, is assessed by matching the job to one of the set occupational classification codes, they're called, which the UK authorities have designated for jobs. So a software engineer will be qualified and would be covered by the occupational code 2136, by which we know that the role meets the requirements. It then needs to score a further 10 points to make up the mandatory 50 points he needs by either taking an English test or having a degree taught in English. So where he's a Spanish national, he can't rely on his nationality here. Now, we know that provided his salary meets the designated going rate, he would be able to score the final 20 points required to qualify. So the going rate would be either 25,600 or the minimum salary that's specified for his job type. So because we know his job type fits into code 2136, I can say that the salary, the minimum salary for that code is 33,300. So Jamie would easily meet that requirement based on his 35,000 annual salary. So that means he would qualify. Now, the software engineer role is currently designated as being a shortage role. So Jamie could potentially trade off any shortfall of any points he doesn't score by scoring points on this basis. It doesn't need to do that here because he already scores the points needed, but it could be relevant if the salary offered was lower.
Okay, so in case study 2, you have Melanie, who's worked for Global Investments Limited for 4 years in the Paris office. Her annual salary is equivalent to £50,000. And the business asks you if she can undertake a 6-month secondment in London in the UK office. Well, given that she has more than 12 months service with the company abroad, and she will be paid above the minimum threshold of £41,500. Based on that, she will qualify for an intra-company transfer visa. So as long as Global Investments has a sponsor license under this route, getting a visa for the secondment should be pretty straightforward. Just before we wrap up, we wanted to hone in on some of the key impacts on the upcoming changes for employers. Now, visa fees are an important impact that we wanted to flag. At the moment, EU nationals don't need a visa, so of course there's no visa costs. But going forward, fees will apply at the same level as non-EU nationals currently pay. Looking at the sponsored visa routes, the visa for a 5-year visa is just over £1,000. On top of that, the employer has to pay the immigration skills charge, which is £1,000 per year of the visa, so £5,000 for 5 years. There is a reduced charge for small employers. Plus, they need to pay the certificate of sponsorship fee of £199. And then on top of that, there is the immigration health surcharge, which is to help pay for the NHS, and that's increasing to £624 a year from October. So over £3,000 for 5 years, which gives you the grand total of £9,539 for your EU national. And that, of course, doesn't take into account fees for dependents, so any spouses or children, and also doesn't factor in any costs for expedited processing fees, which you may also want to pay on top.
Now, to look at the right to work impact for employers, we don't yet have the guidance for employers on how they should approach right to work checks in relation to once the rules change for EU nationals. Because once those change, they will become subject to UK immigration control in the same way as non-EU nationals currently are. So it will be vital for employers to make sure that they are following the new processes once those are introduced and the policies are updated, to avoid getting things wrong and obviously avoid any potential exposure to illegal working penalties. Now, employers are obliged to prevent illegal working. So the current guidance requires that you run checks on all new recruits, and that where appropriate, where you have individuals with time-limited visas, that you undertake follow-up checks for them. So say if you have somebody who is on a sponsored visa with an end date, you have to check before their visa expires. Now, the documents you check and the method that you undertake the checks will depend on who you're checking and what type of status they hold. Now, in relation to your current EU nationals, so as we've said, they're covered by the EU settlement scheme and so protected under the withdrawal agreement that the UK agreed with the EU. They have time to make their applications under the EU settlement scheme, as the deadline is June next year. So during this initial period before the deadline, the government has confirmed that employers can continue to accept passports or ID cards as evidence of right to work. So for anyone already in the UK, they can continue to rely on their passports. Now, where you have new hires that are joining you from 2021, you'll need to check either their EU settlement scheme status, where they've applied, so that will cover anybody who's already in the UK before the transition period ends, or you'll need to check their work visas if they move to the UK from the start of next year and they are covered by the new immigration regime. So that will apply, as we said, to everybody non-British, so including EEA nationals as well as non-EEA nationals. Now, some of the checks are online, because if you're an EU national, your EU settlement scheme status will be issued not on a physical document. It will be issued on an electronic document, so employers will need to check online. Now, if you're making checks for people who are not EU nationals, but they also have status, so they have visas, they will typically hold a biometric residence permit. And some of you may be quite used to checking those. And these documents can be checked either in hard copy or online. Now, British and Irish nationals, you'll of course need to continue to see original passports because their documents are not online.
Thanks, Moji. So to finish up then, what should you be doing now to prepare for next year? Well, first and foremost, it's apply for a sponsorship license if you haven't already. So that's the number one key priority, because you'll need this to employ anyone from outside the UK, so EU or non-EU. And the sooner that you do that, the better, really. Processing times for license applications are currently around 4 to 8 weeks, but as more employers recognise the need to apply, applications are likely to take a lot longer to process due to demand. Although there is a new sponsor license priority process that the Home Office have just introduced this month, that does incur an extra fee. So number one, apply for your license. Second, if you already have one, then do check it carefully to ensure you're registered both under Tier 2 General and Intra-Company Transfer. The existing categories will automatically convert to the Skilled Worker and Intra-Company Transfer if you have these on your license already. If you need to, you can apply to add a category to the license, and again, you should look to do this sooner rather than later. Being a licensed sponsor means you have record keeping and compliance obligations. And as we move into the new regime, we want to make sure you will want to make sure that your house is in order and there are no issues which could put your license at risk. So we've been doing quite a few audits and reviews for a number of clients on that front. Third point is budgeting and planning for the changes. What you want to identify is how reliant you are on EU nationals. So how many do you currently employ, which areas of the business do you employ them, etc. To give you an idea of your recruitment needs in the future. Then look at the costs. So currently there are no visa costs, but how much will it cost you as a business if you had to get visas for all new hires from outside the UK? Finally, there's going to be some training and upskilling involved. As Moji said, there will be a new right to work requirement and there will be new visa requirements. So thinking about what new processes you'll need to put in place and how you're going to train your employees to educate them is key. Okay, that's quite a bit to put on your to-do list, but I think that covers everything that we were going to say. If you do have questions, then please do feel free to either contact Moji or me, or just to reach out to your usual Travers Smith contact within the team. Thank you.